Good evening, and welcome to our TV show featuring documentaries revealing the realities behind myths using research and scholarship. I'm your host, Ergün Kırlıkovalı, and I will be with you every Sunday at 4 p.m. Eastern Standard Time. You're welcome to send me your feedback on our website, mythsandrealities.com, by using hashtag ethocide. Today, we will continue to discuss the legal aspects of the Turkish-Armenian conflict. We will look at some major court verdicts in America and Europe and analyze their significance and impact. Then we will explore some future trends. Convention on the Prevention and Punishment of the Crime of Genocide was adopted by the United Nations General Assembly on 9th of December 1948, but entered into force on January 12, 1951, after sufficient number of members ratified it. The contracting parties have considered the declaration made by the UN General Assembly on 11th of December 1946 that genocide is a crime under international law, contrary to the spirit and aims of the United Nations and condemned by the civilized world. They recognized that genocide has inflicted great losses on humanity at all periods of history. They were convinced that in order to liberate mankind from such a horrible plague, international cooperation was required. They resolved to agree on the following. Article 1. The contracting parties confirm that genocide, whether committed in time of peace or war, is a crime under international law, which they undertake to prevent and to punish. Article 2. In the present convention, genocide means any of the following acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. Article 3. The following acts shall be punishable. A. Genocide. B. Conspiracy to commit genocide. C. Direct and public incitement to commit genocide. D. Attempt to commit genocide. E. Complicity in genocide. Article 4. Persons committing any of the acts enumerated in Article 3 shall be punished whether they are constitutionally responsible rulers, public officials, or private individuals. Article 5. The contracting parties undertake to enact, in accordance with their respective constitutions, the necessary legislation to give effect to the provisions of the present convention, and in particular, to provide effective penalties for persons guilty of genocide or any of the other acts enumerated in Article 3. Article 6. Persons charged with genocide or any of the other acts enumerated in Article 3 shall be tried by a competent tribunal of the state in the territory of which the act was committed, or by such international penal tribunal as may have jurisdiction with respect to those contracting parties which shall have accepted its jurisdiction. Article 7. Genocide and the other acts enumerated in Article 3 shall not be considered as political crimes for the purpose of extradition. The contracting parties pledge themselves in such cases to grant extradition in accordance with their laws and treaties in force. Article 8. Any contracting party may call upon the competent organs of the United Nations to take such action under the Charter of the UN as they consider appropriate for the prevention and suppression of acts of genocide, or any of the other acts enumerated in Article 3. Article 9. Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relating to the responsibility of a state for genocide or for any of the other acts enumerated in Article 3, shall be submitted to the International Court of Justice, or ICJ for short, at the request of any of the parties to the dispute. Article 10. The present convention, of which the Chinese, English, French, Russian, and Spanish texts are equally authentic, shall bear the date of 9th of December, 1948. Article 11. The present convention shall be open until 31st of December 1949 for signature on behalf of any of the member states. The convention shall be ratified and the instruments of ratification shall be deposited with the Secretary General of the United Nations. Article 12. Any contracting party may at any time, by notification addressed to the Secretary General of the UN, extend the application of the present convention to all or any of the territories. Article 13. On the day when the first 20 instruments of ratification or accession have been deposited, the Secretary General shall draw up a report of the proceedings and transmit a copy thereof to each member of the UN. The convention shall come into full force on the 19th day after the 20th ratification is recorded. Article 14. The convention shall remain in effect for a period of 10 years, as from the date of its coming into force. It shall thereafter remain in force for successive periods of 5 years. Any denunciation shall be effected by a written notification addressed to the Secretary General of the UN. Article 15. If, as a result of denunciations, the number of parties to the present convention should become less than 16, the convention shall cease to be in force. Article 16. A request for the revision of the present convention may be made at any time by any contracting party by means of a notification in writing addressed to the Secretary General. The General Assembly shall decide upon the steps, if any, to be taken in respect to such request. Article 17. The Secretary General of the UN shall notify all member states of signatures, ratifications, dates, denunciations, and retractions. The original of the convention shall be deposited in the archives of the UN, and a certified copy shall be transmitted to each member state. If we have to summarize, we have Articles 1 to 9 that are at the heart of the matter, where you have the principles, terms, definitions, all laid down. And Articles 10 to 19, which are basically housekeeping rules, language, how, when. The following articles are most relevant to the discussion of the Turkish-Armenian conflict. Article 1, Principle of Non-Retroactivity Principle. In law, no ex post facto law, 12th January 1951. Article 2, Requirement to prove intent to destroy. Article 6, Requirement for a competent tribunal and due process. Article 9, Venue shall be the ICJ, International Court of Justice. And here are the reasons why. For Article 1, a legal concept needs to be introduced to understand the significance of date. Nullum crimen sine lege, a Latin phrase that means no crime without law. According to fundamental principles of civil law, there can be no retroactive legislation. The most basic moral principle of the legal system is based on this concept of non-retroactivity. It means you cannot enact a law today to judge yesterday. It means that a person or group cannot be punished for an act that was criminalized by law after the act has been performed. Genocide Convention came into effect on January 12, 1951. So only events after this date can be tried. Article 2 requires the proof of the intent to destroy. This was never proven in the Armenian claim of genocide. Just an arbitrary claim was made based on a racist and dishonest reading of history and uncritically accepted by those with ethno-religious bias against Muslims in general and Turks in particular. Turks have a good saying for this, yargısız infaz, which means extrajudicial execution. That is what those who promote the unsubstantiated claim of Armenian genocide as settled history are actually doing. Execution without prosecution or due process. Some of them do not even know the Turkish side of the story. They either have not heard of it or dismissed it out of Islamophobia and anti-Turkism. It's called viewpoint hostility. Armenians will claim that Istanbul courts martial that were held in between April 1919 and March 1920 proved that intent. But upon even cursory examination of the few surviving documents, one sees clearly that these were nothing more than crude kangaroo trials run by political opponents of the Committee of Union and Progress to settle old scores. Hearsay, forgeries, and even newspaper clippings were admitted to evidence to rapidly convict the defendants. The accused were given no access to lawyers and allowed no cross-examination of the plaintiff's alleged evidence or witnesses. To top it all, the court papers were curiously lost. Although Istanbul was under British occupation and the Ottoman archives were under an Armenian's control, they were lost. All of them. They must have been so embarrassed to butcher justice that they probably destroyed the court documents on purpose. We will perhaps never know. Not until the Armenians opened their archives in Yerevan, Istanbul, Jerusalem, Paris, Boston, and other places. We don't know what they're hiding there. Proving intent to destroy as required by Article 2 was not met in another case, the Malta tribunals. The British, as you know, were so frustrated and embarrassed by the partisanship displayed during the Istanbul courts-martial that they sped up their arrests and exile of the Ottoman leaders to the island of Malta, awaiting trials there. At its highest, this group reached 144 members. After searching the Ottoman, British, French, American, and other archives, high and low, for 2 years, the Crown prosecutors came up empty-handed and had to free the captives in 1921. The Malta tribunals thus proved just the opposite, that there was no intent to destroy Armenians on the part of the Ottoman leaders. Amazingly enough, there is even a third case that proves that Ottoman leaders had no intent to destroy Armenians. I am, of course, referring to the Ottoman courts-martial held between September 1915 and June 1916. This is when 1,673 Ottoman soldiers, officers, and some public servants were tried on charges of abuse of Armenian refugees during the relocations carried out by the Ottoman government's Tehcir order of May 31, 1915, which is best described as temporary resettlement, or tereset for short. 659 were found guilty, receiving various punishments, and 67 of those were capital punishments. These trials prove that the Ottoman government had no intention to systematically exterminate Armenians as deceitfully and shamefully claimed. For more information on this, please see Middle East Critique, The Relocations, in parentheses Tehcir, of Armenians and the trials of 1915-16, Yusuf Saranay, State Archives, Ankara, Turkey. It is available online. So we have already seen that the Istanbul courts-martial of 1919-1920 do not prove intent to destroy, and that the Malta tribunals of 1919 to 1921 and the Ottoman courts-martial of 1915 and 1916 actually disprove that there was any intent to destroy. So what kind of evidence are we after? What is a proof of intent to destroy? For that, we will have to go to World War II Germany. On January 20, 1942, 15 high-ranking Nazi and party government officials gathered at a villa in Berlin suburb of Wannsee to discuss and coordinate the implementation of what they called the final solution of the Jewish question. The mass murder of the Jews by Nazi Germany and its collaborators required the coordination and cooperation of governmental agencies throughout Axis-controlled Europe. The SS envisioned that some 11 million Jews, some of them not living on German-controlled territory, would be eradicated as part of the Nazi program. Documents captured from OKW, the German Nazi equivalent then of today's Pentagon, spelled out how the final solution was to be implemented step by step. Now, that's intent to destroy. There are no Wannsee Conference or final solution in the Turkish-Armenian conflict. Some Armenian writers attempted to fabricate some Ottoman documents as smoking gun, such as the alleged Talat Pasha telegrams, but scholarly scrutiny soon exposed them as crude fakes. Some desperate Armenian scholars still shamelessly use such fraudulent documents in their books today as proof of intent to destroy. The Ottoman archives show a great deal of care in detail for the safe delivery of the Armenian relocatees. You read about them in the book by Professor Yusuf Salaçoğlu. The book was called Facts on the Relocation of Armenians, 1914-1918. Another good book is The Great War and the Forced Migration of the Armenians by Professor Kemal Çiçek. Further readings should include the book Armenian Relocations in Turkey by Professor Salahi Ramzan Sonyel and The Armenians in History and the Armenian Question by Professor Esat Vuras. For a study in counterinsurgency, one needs to read Professor Edward J. Erickson's Ottomans and Armenians. In summary, we can safely say that Armenians simply cannot, dare not, bring a lawsuit against Turkey at ICJ, because if they do, then the Turkish side of the story, ignored, dismissed, or censored up to now, will be burst open, heard by the entire world due to the live media coverage, social media frenzy, academic research programs like these, and more. Another reason why the Armenians cannot bring a lawsuit against Turkey at ICJ is because they know that the Turkish archives refuting genocide claims are very strong, relevant, reliable, and consistent. As the Viennese Armenian Turkish or VAT or VAT platform showed in 2005. That's another discussion for another time. Still, a third reason why the Armenians cannot bring a lawsuit against Turkey at ICJ is because the Ottoman leaders' intent to destroy cannot be proven by Armenian claims or alleged evidence. On the contrary, Armenian insurgency to destroy Turks can effortlessly be proven by both Turkish and Armenian archives. Fourth reason why the Armenians cannot bring a lawsuit against Turkey at ICJ is that they have too much to lose. Knowing this well, the genocide industry, cultivated by the Armenian lobby, prefers to thrive on the journey, not the destination, i.e., focus on fundraising and advocacy, not evidence or court verdicts. Fifth reason why the Armenians cannot bring a lawsuit against Turkey at ICJ is the existence of a massive body of literature featuring genuine Armenian confessions on war crimes and hate crimes. All that would be burst open for the entire world to see, hear, read, and learn. Case in question, the Haushamatyan published by the ARF in 2006 in Glendale. I plan to cover that massive Armenian confession of war crimes in a future episode. Now let's talk a little on Article 6, competent tribunal and due process. Is every court competent? No. Does it require special training and experience? Yes. Why? Because the scope and depth of the crime are more far-reaching, terms are more precise, and evidence more complex. Is that why International Court of Justice was created? Absolutely. And what is meant by tribunal? A tribunal is a court of justice. Is a parliament court of justice? No. Is a university panel a tribunal? Of course not. How about a newspaper editorial board? Absolutely not. How about a church, an advocacy group, an association, business people, diplomats, soldiers? No, 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 and no. Yet, all we hear from are these groups. ICJ is the only venue for genocide to resolve genocide disputes. And ICJ is highly qualified to conduct fair trials using due process. That means access to lawyers, records, evidence, witnesses, cross-examination, and more. There is one court of justice designed by the UN for the genocide claims, and that is the ICJ. It was established in June 1945 and began to work in April 1946. The seat of the court is at the Peace Palace in The Hague in the Netherlands. The court's role is to settle in accordance with international law legal disputes submitted to it by states. The court is composed of 15 judges who are elected for terms of office of 9 years by the UN General Assembly and the Security Council. Its official languages are English and French. Only states are eligible to appear before the court, which means the 193 UN member states cannot deal with applications of individuals, NGOs, corporations, or any other private entity. Having explained the UN Convention, the ICJ, and why the Armenians cannot take Turkey to ICJ to have their genocide claim recognized, I would like to end my discussion today with wise words from Professor Gunter Louie. He wrote this in the Middle East Quarterly, fall 2005, pages 3 to 12. I quote, "For genocide scholars, the claims of the Armenians have become incontrovertible historical fact. But many historians, both in Turkey and the West, have questioned the appropriateness of the genocide label. Across the West, Armenian activists try politically to predetermine the historical debate by demanding various parliaments pass resolutions recognizing the Armenian genocide. The key question in the debate concerns premeditation," unquote. What determines genocide is not necessarily the number of casualties or the cruelty of the persecution. It is the intent to destroy a group. Historically, the intent to destroy a race has emerged only as the culmination of racism, as in the case of anti-Semitism and the Holocaust. But Turks have never harbored any anti-Armenianism. Killing, even of the civilians, in a war waged for territory is not genocide. The victims of genocide must be totally innocent. They must not be waging an armed rebellion and fight for territory, but be killed simply because of their membership in a specific group. Obviously, Armenians fought for Turkish lands upon which to build their independent state, and Turks defended their homeland. In July 2000, the British government declared in the House of Lords that, I quote, "In the absence of unequivocal evidence to show that the Ottoman administration took a specific decision to eliminate the Armenians, the British governments have not recognized the events of 1915-1916 as genocide," unquote. This is very significant, as Great Britain was the occupying power after the First World War, and the entire Ottoman archives were at its disposition. If the British could not find any documents to support the claim of genocide then, the Armenians certainly cannot find any now. This is exactly why Armenians can never dare to take Turkey to the International Court of Justice. It would be their end. Yes, that's how crucial is the term intent. Will the deceptive Armenian lobby finally discover the international law? Will the genocide scholars finally remove the gag order placed on them by the racist Armenian lobby and learn the other side of the story? Will Armenia finally open its archives? These are all great questions to explore some other time. Thank you for joining me. See you next week.